On the ruling by the ICC regarding South Africa's decision to not arrest Sudanese President Al-Bashir, we are now joined by Dr. Jakkie Cilliers from the Institute of South African Studies. Dr. Cilliers, thank you so much for joining us. Now, what does the judgment mean for South Africa going forward?
Well, South Africa has 5 days to appeal this. I don't think South Africa will. Because the ruling by the judge is that the case will not be referred to the UN Security Council or to the state parties. And I think Direclade from Durko has already expressed his relief about this, which means that basically South Africa has been found to be wanting in this instance, but that no further action will occur. And that is because on a number of previous occasions, when the International Criminal Court has referred issues to the UN Security Council, or particularly to the UN Security Council, there has been no action. So South Africa has, in a sense, been let off the hook.
Now, Dr. Cilliers, we've seen the ANC leadership in terms of international relations, Edna Molewa, stating the fact that South Africa will continue withdrawing from the ICC. Your take on this after this judgment or this ruling?
Yes, I think South Africa will, the ANC has made it clear that South Africa will continue to withdraw. I think it's a sad day, both for the ICC and I think for South Africa. But I think that generally the view is that South Africa got itself into this problem in the first instance. It should never have invited Bashir to South Africa. And now we're stuck. And it's become a bit of a lightning rod. And the challenge that we have is that South Africa's actions in this regard are a little bit out of step with the requirements of the South African Constitution. Because clearly, once we were in this problem, it was not practically possible to arrest Bashir once he is in South Africa. For a country that has peacekeeping troops in Darfur deployed. So we were really caught in a bad spot.
Now, Doctor, the United Nations has not taken any action against states visited by Bashir in the past. Does this take some weight off this judgment?
Sorry, could you just repeat that?
You know, countries that were visited by Al-Bashir in the past, before he came to South Africa, and some that after he came to South Africa. Does this take any weight off the judgment with regards to the UN against those states where Bashir had visited before?
This is really a domestic issue on the interpretation of South Africa's obligations under our constitution and the law through which we domesticated the Rome Statute into South African law. It's really the problem that government has is that it was seen to be in contravention of the South African constitution, and because it had domesticated the Rome Statute. So it differs from country to country. South African law is very specific in this instance, and there are two explanations about why this happened. On the one side, there is a view that the South African government willfully defied the International Criminal Court and its own constitution. The other explanation is that South Africa got bad legal advice and invited Bashir believing that he had immunity. I think most of us believed that that was naive. The South African Constitution is very clear. Once something has been domesticated, it is part of South African law. And this, as I said, South Africa should have advised Bashir not to come to South Africa. But there's a sense that South Africa was so upset about the impact that the xenophobic riots had on our perceptions in Africa that we were prepared to lean over backwards to try and show our solidarity with Africa, and in the process, government was found to be in violation of its own law and its constitution.
Now, some humanitarian organizations have already come out to say that South Africa was complicit in denying victims of Bashir's crime justice. Is this a fair assessment to make?
I think that's going a little bit far. South Africa created this problem for itself. And as I've indicated, there is clear evidence that in recent years, the South African foreign policy orientation is somewhat at odds with our constitution and our Bill of Rights. So generally, South Africa has become a little bit of a disappointment in Africa with regard to how it is seen as advancing and upholding human rights, democracy, and so on and so forth. Generally, I think South Africa, under President President Zuma, has stepped away from that commitment. But I think it's going a bit far to make South Africa complicit. We had a domestic challenge, a legal issue, and we dealt with it very badly.
Now, Doc, political parties like the EFF, the Democratic Alliance, have expressed different views on the judgment. Are we going to see a more fierce debate around leaving the ICC as the October deadline draws closer?
I think the ANC have made it clear that they do intend to withdraw. I think that if that ball can be kicked down the road, beyond the December 2017 ANC electoral conference, national conference, maybe a new incoming ANC president may take a different view. But I think at the moment the ANC have made it clear there have been two decisions that reaffirm that we are going to withdraw. So I suspect that that is the road that we are going to travel. I think it's a sad day for South Africa. I think it's a sad day for Africa. But unfortunately, as I've said, increasingly our actions in recent years have not been in line with the Constitution, the Bill of Rights that is supposed to frame our foreign policy.
Dr. Cilliers, thank you so much for joining us. We'll leave it there for now. That was Dr. Jakkie Cilliers from the Institute of South African Studies speaking to us there on the ICC judgment on President Omar Al-Bashir's visit to South Africa in 2015.